The courts of appeal as well recognize the very real implications of caseload imbalance on the workloads of their judges and on the speed with which the public's business is handled. We will work with Glenn and others at the legislature and will present a plan to you at the appropriate time for a restructuring of the Supreme Court districts. The courts of appeal have created a committee of their judges and will present to you as well a plan to improve their workload distribution and a method of restructuring, if necessary, to ensure the most efficient handling of the appeals in our state. In the pursuit of making our vision of the judiciary a reality, we are concerned about the public perception of our branch of government. We have read, as have you, disparaging articles about our legal system from some national organizations. We want to know the bases of these criticisms. If they are valid, we want to address them. If they are not, we want to quell them. To that end, the court has appointed a committee to analyze these articles and to address them. I believe our committee is one of the most diverse and distinguished that we have ever appointed. It consists of representatives from the governor's office, including the executive council and senior policy advisor, members of the legislature, including Senators Marino and Amedee, and Representatives Harrison and Abramson, representatives from the Conference of Court of Appeal Judges and the Louisiana District Judges Association, representatives from Lobby and Labor, the Defense Bar, the Association of Justice, as well as the State Bar Association. We are encouraged by the enthusiasm and interest of this group in improving the image of Louisiana's legal system. Though there are many diverse interests and ideas among this group, we all share a love of our state and a commitment to try to improve its image. On the national stage, we are seeing an increase in the number of pro se litigants that are using our court systems. These are litigants that seek to file suit or pursue relief from a court without the assistance of an attorney. This national trend is also evident in Louisiana. Obviously, as the cost of litigation continues to be high and as the economy weakens, more and more of our citizens who must utilize the courts are trying to handle legal matters on their own. The Supreme Court, in concert with the Louisiana State Bar Association, has formed a committee to explore methods of assisting those pro se litigants in navigating the legal system. In states such as ours, where poverty might play a widespread yet unfortunate role in the lives of our citizens, it is imperative that we move in this direction. We must and we will do more to make our courts available and accessible to all of Louisiana citizens, no matter what their means. I would like to quickly mention some of the other advances we have and are making in our court. As you may know, we live stream our oral arguments so anyone can watch from a computer. We stole that from you, as a matter of fact. Our court website is now translatable into 31 different languages, and we will soon be kicking off an e-filing system where court filings can be made via email. Our domestic violence registry is unique in that it reports directly to the FBI and has been recognized by the FBI for its outstanding work. Our security staff, under the direction of Justice Traylor, is one of the best in this country, and we participate in training with the United States Secret Service. We will ask you this year to afford our court security officers peace officer status. We have and will continue to work with you and the executive branch to do our part to address the problems in criminal justice, both in the adult and juvenile areas. In the adult arena, you may know that 1 in 26 adults in Louisiana is under correctional control. 1 in every 55 Louisiana residents is incarcerated. Even more sobering is our recidivism rate, just under 50%. In 2009, approximately 15,000 offenders will be released from our prisons back into Louisiana's communities. They will face huge obstacles such as finding a job, a place to live, and treatment for physical or mental health issues. I applaud Secretary LeBlanc's commitment to try to reduce this recidivism rate through reentry programs, preparing an offender for his return to society before he is released from prison. The Secretary and I have spoken about the critical importance of pre-release preparation and the associated cost-benefit to the citizens of Louisiana when an offender successfully re-enters our communities and becomes a productive law enforcement and tax-paying citizen. Perhaps more important in reducing recidivism is an examination of our sentencing and correctional policies. You recently reenacted the Louisiana Sentencing Commission, which I understand will undertake the task of examining this state's sentencing policies. I commend you for that step, which will go a long way towards controlling the growth of Louisiana's prison population, and which will work in tandem with Secretary LeBlanc's reentry initiatives. We have worked with you to develop one of the most extensive drug court programs in this country because we know these programs work, and a successful drug court graduate contributes to society rather than drains it. Our drug court judges devote many, many, many hours to these programs in addition to their regular dockets. Most of them do their staffing each week early in the morning before they start court for the day. They put in this extra time because they realize the value of these programs. We have started to explore other kinds of specialty courts, such as DWI courts and mental health courts. While I recognize the potential benefit of these problem-solving courts, I believe we need to proceed cautiously and deliberately to ensure uniform standards, accountability measures, and monitoring mechanisms. To this end, we have just applied for a federal grant to add expertise in these areas and to explore appropriate standards and best practices for our judges who are willing to take on yet other problem-solving court programs. We want them to have the best training and employ the best methods possible for this new kind of judging. Ideally, these programs will have the ultimate effect of reducing required by both the United States and Louisiana constitutions is our obligation to provide and your obligation to fund adequate representation for indigent defendants. While not usually considered perhaps as a cost-saving method, the victims and the defendant must relive all of the emotions of capital crime. Adequate resources for indigent defense can significantly reduce the likelihood of delay and provide a better initial trial experience. I urge you to continue what you started in reforming indigent defense and to provide it with adequate resources to perform its constitutional functions in our criminal justice system. I'd like to now turn to a subject that is very dear to my heart, Louisiana's juvenile justice system. As many of you were not here in 2001 when this effort really began, I will give you a very brief history of where we were and how far we have come. Just over 10 years ago, in 1996, the United States Department of Justice wrote then-Governor Foster informing him of life-threatening and dangerous conditions at the state's juvenile facilities, and noted that 28 children from the juvenile facility in Tallulah had been sent to the hospital for evaluation and/or treatment of serious injuries, including fractures, suspected fractures, and serious lacerations in need of suturing. Eventually, the Department of Justice filed a lawsuit over the conditions of Tallulah, accusing the state of Louisiana, widely believed to have the worst juvenile prisons in the country, with failing to protect juvenile inmates from brutality by guards and providing inadequate education, medical, and mental health care. In reporting on the situation, the first line of a blistering article in a national newspaper read, quote, "Here in the middle of the impoverished Mississippi Delta is a juvenile prison so rife with brutality, cronyism, and neglect that many legal experts say it is the worst in the nation.